Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with closing attorneys holding earnest money. So when you are negotiating a contract, writing a contract and negotiating back and forth, there is a place in the contract for the buyer and the seller to choose who will be the holder of the earnest money. And typically we see the selling agent's broker as the holder of the earnest money. We definitely encourage that either the listing broker or the selling broker be the holder of the earnest money. Now, again, the buyer and the seller negotiate who the holder of the earnest money is, and there's a place to fill in who that is, when it's to be remitted, and so forth and so on. The holder of the earnest money is charged with many responsibilities in both sets of contracts, the GAR contract and the RE forms contract. The holder of the earnest money has to deposit it once it's received, and those time frames are different in the GAR and the RE form. Now, this isn't when the buyer remits it, but once it has been remitted by the buyer, the holder has to make that deposit, number one. Number two, the holder has to send notices if the earnest money was not remitted timely or was not honored by the bank. So if you think about it, your contract, your purchase and sale agreement, in essence, is a receipt for those funds, for that money. When you are an agent, you're an affiliated licensee, you're affiliated with whom? You're affiliated with your broker. So when you sign the contract, you are saying that if you have whomever is listed as the holder of the earnest money and you have X amount of dollars, when you sign the contract, in essence, you are saying it is a receipt that the holder of the earnest money, whoever is listed there, has received those funds and will make that deposit because that's what they're charged with in the contract. If there's no other information given that they never got it, then that is a receipt for those funds that the holder is responsible for, has. So both sets of contracts have, again, the responsibility to make the deposit, give notices if they haven't ever given it, and then decide how to disperse the earnest money at the end of a contract if it closes or if it fails to close. So let's go back to the notice section for a minute. If the holder of the earnest money never gets the earnest money, the buyer fails to timely remit those funds as they said they would in the contract, or the check bounces from the bank, or for whatever reason the bank doesn't honor those funds, the holder has to send notice to the parties, to the buyer and the seller, that says, hey, I don't have that money. Number one, it protects the holder because, again, as the receipt, this is a receipt saying I got the money, and so you have to send notice, I never got it, and if it bounces if it's not honored by the bank, then the holder still is not in possession of those funds. So not only does that protect the holder by saying the holder is not in possession of those funds, but number two, the buyer and the seller have certain rights and responsibilities after receiving this notice. So the buyer has defaulted on the contract, and the buyer has the right to cure, to make good on the earnest money, so to speak. Either remit the funds as they said they would, or make good in another source of funds so the bank will honor those funds. Now, the time frames within which the buyer has to cure this default is different in the GAR contract and the RE forms contract. So go back and read your contracts and make sure that you understand those time frames to cure. If the buyer, however, fails to cure the default, so you've got notice from the holder, there's no earnest money, the buyer fails to cure the default, at that point, the seller has termination rights. Now, again, these rights are timed. There are certain time frames within which they have to act on that if they do want to terminate. But if the seller wants to terminate, they can do so. If the holder never gives notice that there's no earnest money in the deal, the seller is being denied those termination rights. And just think, in a multiple offer situation, if the seller, not a multiple offer, but in a backup offer situation, if the seller has a backup contract for more money or different terms, the seller might want to terminate this contract to go with another contract. Now, the seller does not have to terminate the contract. The seller may go on and demand full performance of the buyer with the rest of the terms of the contract. But nevertheless, the holder has to give notice to give the buyer and the seller their rights with respect to the contract regarding what they want to do and how to proceed. Now, the third responsibility that the holder of the earnest money has to do is disperse those funds at the end of the contract. Now, if the contract closes and everything is fine, then the holder, that earnest money, typically received by the buyer, it gets credited at closing as part of what the buyer owes. And so the holder has to make sure that it gets dispersed properly in accordance with that. If, however, a contract fails to close, as I teach in my classes, nothing is ever an issue until it's an issue. So if a contract fails to close and it terminates, everybody wants this pot of money, this earnest money. Well, it depends if it terminated by an unexpired contingency or if it terminated by default. Now, for the holder of the earnest money to disperse the funds, they need written agreement between the buyer and the seller agreeing to the disbursement of the funds and how the holder is to disperse those funds. Typically, we refer to that as the termination and release agreement. And in the GAR form, the termination and the release is on one document. In the RE forms, it's two separate documents. One is the termination and one is the agreement to disperse the earnest money. Now, termination of any contract is unilateral. So any party can terminate, and once it's terminated, it's terminated. What's at issue is what happens to the earnest money. You need agreement for the holder to disperse those funds, the trust money, the escrow money. So you need both buyer and seller signatures on the TNR or on the agreement to release the trust funds in order for the holder to fulfill that and disperse the earnest money in accordance with their wishes. So if you do not get buyer and seller signatures, the holder has several things that the holder can do to disperse the earnest money, because the holder can't just keep those funds in their account for forever. So one of the things that the holder can do, number one, if there's an issue, the issue is too legally complicated, or just if the holder chooses to, the holder can interplead those funds into the registry of a court of competent jurisdiction to handle that issue. There is a cost to that, to file that motion, and the holder gets to deduct their fees and their costs to file an interpleader action, and then a judge decides who gets that earnest money. Now, the other thing which typically happens more often is the holder of the earnest money in the contract. And your contract, you guys, is merely a set of instructions. That's all it is. And the instructions in the GAR contract is outlined in the purchase and sale agreement, and the instructions in the RE forms contract is outlined in the purchase and sale agreement combined with the standard terms. And it's all outlined in there. But basically what the holder does is the holder is charged with determining what happened. Why did it fail to close? Did it fail to close based on one of the parties' default, or did it fail to close based on a contingency that had not yet expired? So the holder has to do all sorts of research. Go through the contract, look at the terms, see what the buyer and the seller agreed to, see about the time frames, see what documents were sent, were signed, were they sent, was notice given appropriately to the appropriate party based on the instructions, i.e. the contract, and within the time frame. If a buyer terminated within an unexpired contingency and the seller doesn't sign the release agreement, the holder still has to go through this entire process to determine was that termination based on the contingency that the parties had agreed to and the seller just isn't signing it. Or did the buyer default on the contract? Did they terminate outside of their time frames, outside of due diligence, or did they terminate based on a financing contingency but not meet all the terms of the financing contingency, or not give a loan denial letter, or so forth or so on? There's all sorts of information that the holder of the earnest money has to go through to make the determination regarding dispersing these funds. And they have to go through, interpret the contract, interpret what happened, check out the time frames, check out the contingencies, and check out the notices, then send the notice to the parties regarding their decision to disperse this earnest money. And typically we refer to this as the 10-day letter. The reason it is referred to this is in the GAR contract, basically once the holder goes through this determination and sends their notice of their decision to disperse the earnest money, the party not receiving the earnest money has 10 days to make an objection to that. And then again, this whole information is outlined what happens if it is a valid objection or so forth or so on. But again, this letter is called the 10-day letter, and it does go to the parties. Now, after the 10-day letter, then the holder can disperse those funds. Now, it's very important too, because if the buyer has defaulted on the contract, then the seller, if the holder disperses those funds to the seller and the seller deposits those funds, that constitutes liquidated damages, and the seller then no longer has the right to sue the buyer for the default because they've accepted the liquidated damages for the buyer's default, and everybody goes on. So lots and lots of responsibilities being the holder of the earnest money regarding these escrow funds, this trust money. So again, let me go back to something I just mentioned a little while ago. When you sign on with a broker, you are doing all business is done in the name of your broker, and you are an affiliated licensee with your broker. So when you sign on with your broker is allowing you to sign contracts in their name, and because of that, they are allowing you to engage them in the responsibilities of being the holder of the earnest money if they are the ones that the buyer and the seller negotiate as the holder of the earnest money. And if the 10-day letter, let's say the broker has to go through and make a competent decision regarding the disbursement. They can't just give it back to their client just because it's their client, because your brokers all have real estate licenses and they are held to license law just like agents are. And it is a license law violation of incompetency if the broker disperses earnest money against something that is contractually allowed for in the contract. So both brokers hold licenses and are held to license law and have to competently interpret the contract to make this disbursement. Now, a closing attorney holding earnest money, where in your contract do you see your closing attorney's signature? Nowhere. So the buyer and the seller are negotiating to have this closing attorney hold these funds, and the closing attorney, nowhere do they sign the contract. So you have a client, a buyer, giving X amount of dollars to a closing attorney with no paperwork. The closing attorney doesn't agree to fulfill those responsibilities. Nowhere in the contract do they sign. They don't agree to make the deposit. They don't agree to send any notices. They don't agree to resolve any disputes over the earnest money if it fails to close. And it just, there's nowhere that the closing attorney agrees to do that. Now, don't get me wrong, you do have some great closing attorneys that will fulfill the responsibilities of holder even though they don't sign the contract, but in general, nowhere do they sign the contract to agree to do that. And yet we see contracts on a routine basis where the buyer and the seller negotiate to have a closing attorney hold the earnest money. Now, your closing attorneys are great at closing transactions. They're not all necessarily good at being holders of earnest money and going through all the processes and the notices that they need to do. Now, one thing I will tell you, as an agent, it is totally your responsibility to follow up with the deposit of the earnest money, regardless if it's a closing attorney that's the holder or your broker or the other broker. You absolutely need to follow up with the deposit of that. Who cares about a pretty picture, a copy of a check? That's just a pretty picture. What you need to be, what's important to your client is, were those funds deposited, received and deposited per the terms of the contract. So we have been teaching this in our classes for years. I have been begging agents to not put closing attorneys on the contract as the holder of the earnest money. Now, if you do, I have asked you to make a call and contact that closing attorney and get something that they do agree to fulfill those responsibilities, because there are lots of issues where that affects the buyer and the seller, and in turn, you, the agent. So guess what? GAR has finally listened to me, to us. Thank you so much, GAR, Georgia Association of Realtors. We so appreciate this form. There is a brand new 2017 form, F84, Agreement for Escrow Agent to Serve as Holder of Earnest Money. Thank you, thank you, thank you, GAR. So, agents, if your buyer and your seller negotiate to have a closing attorney hold the earnest money, you absolutely want to complete this form and send it to the closing attorney before negotiating the rest of the contract. So let me tell you a little bit about this form. It basically says, number one, escrow agent agrees to perform the duties of holder under the agreement, a copy of which is incorporated herein by reference. Number two, it says that the escrow agent as holder shall deposit the funds, hold the funds, and then disperse the funds in accordance with the terms of the agreement, which is everything I just outlined per your instructions, i.e. the contract. And there is a place in here that the escrow agent, in order to fulfill their duties as holder of earnest money, there is a place where the buyer and the seller and the escrow agent can negotiate for an additional dollar amount as a fee for somebody other than the broker to hold those funds. Buyer and seller and escrow agent can negotiate that fee to zero, but make sure, don't leave that blank. Make sure that you notice that's in that form. Most importantly, you guys, there is a place for the escrow agent to sign and the escrow agent's address. So if you are going to have the closing attorney hold the earnest money, you absolutely need to get their signature that they do agree to fulfill their responsibilities as the holder of the earnest money as outlined in your contract form. So again, thank you so much, GAR. We greatly appreciate this brand new 2017 form. However, I do encourage agents to still have one or the other broker hold the earnest money rather than the closing attorney. Because if it takes a lot of time to go through and make the interpretation, determine what happened, why it failed to close, track down emails to make sure notice was sent in time, make sure notice was sent to the proper parties, and so forth and so on. And closing attorneys aren't necessarily going to fulfill those responsibilities, but they do sign this. The other thing is your brokers are held to license law. Your closing attorneys are not held to license law. They're held to laws, but they're not held to license law those license laws that are enforced by the Georgia Real Estate Commission unless they hold a real estate license. So I hope this helped you guys. Thank you again. Great new form. F84, Agreement for Escrow Agent to Serve as Holder of Earnest Money. This is a GAR form, Georgia Association of Realtors. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.